Welcome back to A Father's Rights podcast. My name is Chris Jackman, owner and attorney at the Aberdeen Law Firm in Houston, Texas. Today's episode is our first episode. I'd like to talk to you about the overview of the family law process. And I want to do this because a lot of my clients, when they call me, it's the first time they've ever spoken to a lawyer in their life. And if you're listening to this or watching this, it very well may be true of you as well. And the legal system is confusing. There's a lot of legal jargon. If you're like a lot of my clients, you probably researched things online. You've Googled all kinds of different terms and tried maybe to do this on your own. And you probably got pretty overwhelmed because it is a daunting, intimidating process. And I just want to break down the really key elements of a divorce case. And my guess is that this will probably connect with you and you'll probably realize a lot of what I'm saying does apply to you. And my hope is that you come away with this episode or leave this episode with a pretty good understanding and a good grasp of how the divorce system works in Texas. First things first, you're going to hear the term dissolution a lot. Dissolution just means divorce. And so when I say, or if you hear that term or see it when you're going through court documents, just understand that we're talking about one and the same thing. I use the word divorce. If you're like a lot of my clients, chances are that you've been served with papers by your ex. Statistically speaking, most of the time, men are the ones who receive the divorce. They're not normally on the ones, or not the ones actually initiating the divorce. So if you have received documents, you've probably received what's called a summons, and all that document says is that you've got a set amount of time to respond. Normally here in Texas it's 20 days, other states it's 14, but in most places it's 14 to 20 days that you have to file a response to whatever the documents say that are in front of you. Now, will something horrible happen, or will you lose your case if you respond on day 21 or even day 30? No, because a lot of times what happens, or has to happen I should say, is that if your spouse, your ex, wants to really force the issue because it's been, 25 days, 45 days, and you haven't responded for whatever reason, your spouse has to file what's called, or your spouse's or your ex's lawyer has to file what's called a default. And to do that, you got to file what's called a motion. So you have to have a whole court hearing to basically say, hey, client, have not responded to these documents, therefore everything that we've asked for should be ours, whether it's custody, your house, your 401k. So on the one hand, if you don't respond, eventually the repercussions could be dire and you really could lose your case, but it's not an automatic thing. It's not as though if you don't respond by day 20 or by day 14, it's going to happen. There has to be a full-blown court hearing before those things can happen. The other word I just mentioned a moment ago that you're going to hear a lot and see a lot is called a motion. And that is just a legal document that has to be filed with the court, usually by a lawyer, that explains what you or your lawyer want to happen in a case. So if your ex or your ex-partner or your spouse wants to get custody, they need to file a motion to get custody. If they want to get your home or your car, they need to file a motion requesting those things to happen. So you're going to hear me a lot through this podcast talk about motions and what they do and what they can do. But think of that as kind of the vehicle or the tool that your lawyer or you, because you can file a motion too, have to do to get what they want from the judge. The judge just can't read your mind or read your lawyer's mind and give you what you want. There has to be a formal way to have that happen. And as you can imagine, getting into court nowadays is not easy. Unless you can show it's truly an emergency, it's going to take a couple weeks to even get in front of the court. But you have to file the appropriate documents before you get that court hearing. So to go back to what I mentioned at the outset of our episode, there's a good chance if you're listening and watching this that you've probably been served with these documents. A lot of times it's done by a professional company. And if you're going through those documents, you're probably going to see a couple different things. You're going to see what's called a petition for a dissolution, which is just the document that explains that the marriage or the relationship is over. You're probably going to see in there documents that describe how your children are going to be parented in terms of visitation, who's going to pick up your children. That's called a parenting plan normally. You're probably also seeing some documents in there for child support. Anytime you're filing for child support, you're requesting it, you have to provide evidence of what your income is. So you're probably seeing in there bank statements, you might be seeing pay statements, and then there may be a court hearing because if your ex wants to get visitation or wants to get custody of your children, there has to be a court hearing for that. And a lot of times those are scheduled 2 to 4 weeks out from when you receive those documents. So again, a lot of times there is urgency for you to respond to those documents, hire a lawyer to defend you, because that court hearing is what's called a temporary court order. And it's just what it sounds like. It's an order that's temporary in nature, because another document you probably saw also was a case schedule. And a lot of times, especially in Harris County and other counties that are in larger cities in Texas, you're not going to get a court date or a trial date for about a year. And so that's why we have these temporary order hearings. So that way you're kind of held over until your trial date. So just to kind of recap, the cases, any kind of case is always initiated by the petition, which is usually the petition for dissolution, the child support documents, child custody documents, and chances are, again, there's going to be a court hearing fairly quickly, okay? And again, you need to respond to those within about 20 days. Now, the next step is for you to respond and for you to have your own documents. So you need to respond and give your version of what you want to happen. Now, sometimes my clients don't want the divorce to happen. You know, they want to stop the divorce, and unfortunately, you can't do that. You know, all you can do is respond in terms of what you want the custody to look like, if there's children involved, what the visitation is going to look like. There's probably a pretty good chance that your ex is asking for what's called spousal support. You're going to hear terms like alimony, maintenance, alimony, spousal support. They're the same thing. They're really just talking about one spouse is requesting the other spouse to pay some amount of money. And now this is on top of child support. So don't confuse the two because they are completely separate. A lot of times my clients ask me, hey Chris, how do I know how much spousal support I either need to request? Because you can request spousal support. There's no rule that it has to be one way or the other. How much should I request or how much should I receive? And the law is not super clear on this. So it's based on what's called a ability to pay and a need to receive. So to kind of break this down, and there will be future episodes I'm going to do where I break this down in greater detail and probably show you some hypothetical numbers so you can get a really concrete understanding. But remember, today's episode is just a general overview. But, you know, if one spouse makes a great deal of money and the other spouse is not working at all, you know, that would be an obvious example, right? One spouse has the ability to pay, the other spouse needs money, right? So that would be a clear example of how that would work. Child support, on the other hand, is crystal clear. There's really no room for argument like there is with spousal support. Child support is simply a worksheet. If you've received these documents, you've probably seen them. They're very much a black and white math-oriented document. You plug in how much money you make, you plug in how much your spouse or your ex makes, and there's various deductions, right? There's deductions you're going to see for taxes, for all of your living expenses, and that formula is going to give you a number as to how much you either have to pay or receive. It's very black and white. If you reach out to us, we're more than happy to walk you through what those numbers are. But I always tell my clients that child support, absent some extreme, unusual circumstance, is not something that people should be arguing over. Spousal support I get because it is gray enough, so to speak, that you can make arguments as to why it should be a higher number, a lower number, why it should be maybe for 6 months as opposed to 16 years, because I've seen everything in between. But child support is a very black and white document. So when we're talking about documents you need to fill out, you have to file a response as to your version of events, as to what's going on in the divorce. You have to file a response for the parenting, for what that's going to look like. And then you have to file responses for spousal support and child support. And you need to provide documentation to support that. Most courts are going to want to see 2 years of tax returns, and then things like bank statements, payroll statements, if you're getting pay statements from your work. Normally they want 6 months of those. So you need to have those financial documents. Obviously you want to black out or edit out account numbers and that sort of thing. But those are the documents the court, and when I say the court, I'm really talking about the judge, that the judge is going to want to see to help make a decision. Most importantly, if there is what's called a temporary orders hearing coming up, a court hearing, you need to file a response to that as well. Otherwise, again, your ex is just going to get whatever they're asking for. So that's the first month. And I can tell from talking to my clients, they're always surprised how much work there is in the first month. There's a lot of work, a lot of documents that have to be filled out. Once those are completed, and that once those are filed with the court and submitted, and if you have a court hearing, after the end of that court hearing, things kind of settle down. The dust kind of clears, and there may not be anything for you to do for a number of months. And it's really going to be up to you and your lawyer as to what the next steps are going to be before trial. Typically what I see, and before I get to what I see as kind of the middle ground, so to speak, of your case, I do want to touch briefly on this temporary orders hearing. In the days of COVID, 2020, 2021, even into 2022, these hearings were held on Zoom, but for the most part now they are back in person, just like they were before 2020, where you and your lawyer, if you have a lawyer, have to go to court and you get to make an argument to the judge. I can tell you, from having done hundreds and hundreds of these over the years, my feeling is that since you submit all of your materials beforehand, which can be witness statements as well, in addition to your response and your child support documents and your spousal support documents, that normally the judge has already made up his or her mind. So I always feel like these hearings are kind of unnecessary, but you do get the opportunity to go. And I want to be clear that this is not trial. So this hearing is temporary. It's a short hearing. Normally you and your lawyer get 5-10 minutes to make an argument, and then a decision is made. So I don't want to give you the impression that you're going to have all day or all week to put your case on to the judge to get what you want. It simply doesn't work that way. And normally the judge makes a decision right there as to what the temporary order is going to be until trial. So to finish that thought, that's finished, and you then go on to what I call the middle stage of your case. And this middle stage could last anywhere from 2 months to 10 months because your trial is normally about a year after the date that you file, or after that the day that your spouse files for divorce. And during this time, it's really your opportunity to do what's called discovery. And discovery is just what it sounds like. It's a chance for you to discover more about your ex's or your ex-spouse's case to figure out if it's frankly worth it or not for you to go to trial. And to give you an idea of things that you may want to discover, quote unquote, it could be things like, where are your children living now? If you unfortunately don't win that temporary orders hearing, it may be that your child or your children are living in another home with your ex, and you may want to find out, what are their living conditions like? Are they living in a good, stable environment, or is it a little rough? You may feel as though that the amount of money your spouse is requesting in spousal support is simply too high. Well, this is your opportunity to figure out, is your spouse being truthful with how much money they're making or not making? You may need the opportunity to get, even an accountant involved to go through the finances and figure out, What is your spouse making? Does your spouse have a 401k? Does your spouse have family help that's contributing to his or her financial situation? So those are all the common examples that I typically see that why a case, in many cases, can drag on for 6, 8, even 10 months. Because those things take time, right? And unfortunately, in many cases, if it's a close call, and it often is, as to who the more fit parent is, so to speak, a lot of times the judge will assign a person that's essentially a social worker to do an investigation. CASA is CASA is the term you often might hear, and they're essentially social workers that are paid by the court or by the county to do an investigation, and they're going to interview you. They're going to interview people in your life that are close to you. They're going to interview obviously your ex, and these individuals will then write a report, submit it to the judge, and the judge will then read that report. And 9 times out of 10, the judge is going to adopt whatever recommendations, whatever findings are in that report with respect to child custody. So these interviews that you have with these kind of de facto social workers who are investigating the case are extremely important. And you need to be prepared. Your lawyer, frankly, should be preparing you for these interviews because, again, every single time I've gone in front of a judge for a trial, it's very rare that the judge isn't just going to sort of blindly accept whatever this individual recommends to the judge as far as custody. So as you can imagine, the courts are very backed up. These individuals are hard to find. So just understand that's also a reason why these cases can go on for 6, 8, 10 months. Once that discovery stage is over, and once you've figured out what you need to find out, and obviously the tables could get turned on you as well. Don't be surprised if your ex is requesting, or her lawyer or his lawyer is asking for your bank statements, right? And your supporting financial documents to be seen. That's very common. Once all of that's done, the next step is what's called mediation. And that is normally the very last step before you get to trial. And the stats will tell you that 90% of cases will resolve at mediation. And a mediation is held by a mediator. A mediator is typically a retired judge or an active family law attorney who does this as his or her either kind of side hustle, if you will, or they may be full-time mediators. I see both all the time. But this individual's job is simply to come to terms with you and your ex and their lawyer. It's not the mediator's job to make any decisions. The mediator isn't a judge, right? So the mediator isn't going to tell you this is how much you have to pay in child support. This is what the custody situation is going to look like. The mediator is not there to do that. The mediators are there just simply to facilitate dialogue, to try to get your case to settle, to try to get you and your spouse to come to an agreement so you can avoid trial. Now, a good mediator, and I only work with a handful because there are some bad ones out there, as you can imagine, but a good one is going to make strong recommendations based on their 20, 30, 40 years of experience doing this. And I can tell you, if you have a good mediator, it's pretty rare that your mediator is going to give you bad advice. Because 9 times out of 10, you have to pay for the mediator, as does your spouse. So this mediator isn't biased in any way. They're just going off of what they feel like is likely going to happen in the event that your case goes to a courtroom. As I mentioned before, 95% of cases will settle at that point. And once the case is settled, you're going to sign some documents, your case is over. Now, for that 5-10% of people who don't come to an agreement at mediation, the last step in your case. And so if you're looking at timeline-wise, we're probably talking roughly a year from when you either filed, if you were the one to file for divorce or for custody, or from when you received those documents. That's when you're going to go into a courtroom. And here in Texas, for the most part, judges decide the cases. It's very rare that you're going to have a jury decide it. And I can tell you trial is rarely in your best interest. It's not predictable. The judge can go either way, especially on custody issues. Again, child support is very black and white. On another episode, I'm going to talk about how property is divided, i.e. your 401k, your home, your cars, that sort of thing. But I can tell you that custody it can be a coin flip. And so that's why I always encourage my clients, and any good experienced lawyer will encourage their clients to settle at the mediation or even prior to that. Because it's not as though you can't study your case in month 3. It's just if it's a hotly contested, really bitterly disputed case, normally it's not going to get done until mediation. But again, you may go to trial, and it's impossible in a podcast like I'm doing here to predict what the trial would look like without knowing your particular circumstances. But normally they last a couple days. They're normally very expensive for you, the client, because you got to pay for your lawyer's time. Chances are there may be an expert or two, such as an accountant or someone who may have to value the home. And those are all costs that you have to pay, right? And so that's why it's normally best for you to try to settle your case and not go all the way to a trial. But again, the trial is the very last step. And the judge rarely makes a decision on the last day of trial. Normally what happens is the judge will say, I've heard all the testimony, I've seen all of the evidence, and I'm going to take this under advisement. I'll get you a written ruling within a week. Sometimes this is as far as a month. But usually within a week to a month, you will get a final decision as to what your future is going to be, what the custody will look like, what the child support will look like, spousal support. All of these issues that you and your spouse have been arguing over since you were served or since you were filed, they will get finalized by the judge. And that's something that you have to live with. Now, could you hypothetically appeal the judge's decision and go to the Court of Appeals? You could. But just understand that's difficult. Chances of you winning an appeal aren't really high. So normally when the judge issues his or her ruling on the case, that's it. It's finalized. So before we conclude and wrap up today, because I know I've given you a lot of information on the overview of how these cases work, I just want to give you a brief kind of 3-point recap. First point is that the case is initiated by filing a lot of court documents. The most important is called the petition. Those documents get filed, you have to respond to them within a reasonable time frame, normally about 20 days. After that, there's normally going to be a temporary court hearing. From there, you move on to the discovery stage. That could last anywhere from 2 months to 10 months, where each side is figuring out the other side's cases, or other side's case, possibly talking to witnesses, reviewing documents, that sort of thing. The last stage of the case is the mediation. That's where you meet with your lawyer and the mediator, and you try to come to an agreement. So that way you can avoid the last and final stage, which is trial. And that's, I can tell you, that's what you want to avoid. I hope this has been helpful. I look forward to the next episode.